This is Tampa Bay's 10 Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
And that's right. This is FLA Law live on the radio. As you know, we are the personal injury attorneys at Perenich, Caulfield, Avril Noyes, one of the oldest injury law firms in the Tampa Bay area. And as you know, we come to you live every Tuesday at 5 o'clock with your live legal call-in talk show. So hopefully you've been a faithful listener and you know that we are here every Tuesday at 5. But if not, and you're new to the show, please tell a friend, phone a friend, text a friend, tell them to tune in, because this is your opportunity to call in with your live, on the live show with your legal questions. I do have my esteemed colleague and partner, Brian Caulfield, who is our special co-host tonight. And he obviously is going to be answering legal questions and topics with us tonight. So feel free to get your calls in tonight as we talk back and forth about different personal injury and legal issues. We want to hear from you. That is obviously the premise of the show. It makes things go by very well if you call in with your questions. So I'm going to tell you how to do that and how to keep listening. Of course, if you get out of the car and you want to keep watching, you can do that because we are streaming live right now on 2 different platforms, on Facebook and also on YouTube. So if you have a Facebook account and you'd like to keep listening, even if you can't continue to tune in on the radio, you can stream us on Facebook. So go over to our Facebook page at Perenich, Caulfield, Avril Noyes Injury Lawyers. Put that in your search bar. You should be able to find us right now. We're live in the studio with Brian and I, and you can see us and also drop your comments in the comment section. So if you'd rather ask your question that way, you can do that. And I'll read those out, and Brian and I will, of course, tackle whatever you throw our way. And if you don't have Facebook, but you still want to watch online and see us live or leave a comment, you can do that on YouTube as well. Same name, Perenich, Caulfield, Avril Noyes Injury Lawyers. Type that into YouTube. You should see our logo, should be lit up red. That'll let you know that we are live, and you can go ahead and watch that way. We do encourage you to share with your family, friends, loved ones. They may have questions, even if you don't have one tonight. Somebody that you know may have a question, and this would be great to get the word out to them so they can call in. The number for the station is 727-441-3000. Again, that's 727-441-3000. That's going to be the phone number to dial in tonight to get your questions answered live on the air. With that being said, as I said, we're personal injury attorneys. So, of course, the topic for tonight is going to generally, center around personal injury topics. But I wanted to jump into a conversation with Brian about, of course, we're still on the heels of the devastation from Hurricane Helene and Milton. Of course, I know impacted you personally. And I'm just kind of trying to still figure out how this is going to play out for the people in the state of Florida, especially in our area, now that the laws have changed in the way attorney's fees are going to be paid in these kinds of claims. I'm concerned that there's no longer the direct pay of fees from the carrier, which is how these cases were generally handled prior to the reform bill. And now that is no longer the case. So I just want to get your thoughts on that, Brian, to see what do you think is going to happen to these claims, and are attorneys still going to be taking these cases?
I think they will, but while unfortunately the world was asleep last year, consumers had no idea what was happening to them in Tallahassee. And what was happening is over 100 years of Florida law was upended, turned on its head, because the law in Florida historically, for, as I said, literally a century, had been that if you were caused to have to get into an argument with your insurance company because they denied your claim, for example, if you have windstorm damage to your house and your insurance company says, no, we're not going to pay for that. And you say, well, look, I've got all the evidence that indeed it's from the storm and it's compensable loss. The old law was if the insurance company wouldn't pay you, you could go out, you could get a lawyer, you could explain to the lawyer what the case was about. The lawyer, if they felt the case was strong and that they had a good chance of winning, they would agree to take your case on a contingency fee, meaning that you wouldn't have to pay them anything unless and until they won the case.
Right.
And the good news about that is, say, for example, that your total damages were $100,000 or let's say $50,000, and you won the $50,000 in a jury trial. Well, under the old law, good news. Your attorney got paid over and above that by the insurance carrier. And so that means that you had that $50,000 to go ahead and fix the loss that was going to cost you $50,000. But under the new law, no such right exists. They've taken away the first party insurance statute. And so you take that same example, you win $50,000. Well, number one, you're not going to be able to get an attorney on a contingency. You're going to have to pay that lawyer hourly.
Right.
So you might have to pay that law firm and its lawyers perhaps $20,000 out of the $50,000.
Right.
And so what that really does is it takes away the insurance company's incentive to settle claims fairly. You're pretty much at their mercy, and if you don't agree, then you're going to have to calculate into how big your dispute is. It really makes it much more difficult for the smaller type disputes, 50,000 and below, to be able to effectively go get a lawyer and make it worthwhile. Because even if you win, if you're paying, half the amount you won out to win, it really makes it very, very difficult. So that's a law that changed while really without much fanfare.
Right.
Because people just didn't understand what was happening to them.
Right.
And so now you're going to see a lot of cases around the state of Florida. And, unfortunately, a lot of consumers are going to be surprised to hear that a right that they had enjoyed for over 100 years here in this state has been turned on its head.
Yeah, and I think even the legislators themselves didn't quite realize what they were, voting on. And so I now have heard that some of them are now trying to move towards another reform of some kind, and are, I guess, realizing that wasn't that good of a decision that we just made. We just kind of screwed everyone over, and now we've got to fix it. So that should be interesting to see. And I know you've handled cases like this in the past with other storms. I'm kind of putting you on the spot here, but do you foresee that you will be helping with these kinds of cases with Milton and Helene? Yeah,
of course, we've already started getting calls. And then, look, the flood insurance is a whole different animal. The flood insurance under the National Flood Insurance Program, basically, the United States Congress wrote the terms of that coverage. And then, certain authorized insurance companies write the actual coverage, but it's really under a framework that's built by the National Flood Insurance Act. So that's been around for many years, but there again, attorney's fees not generally included in that. So,
right.
I think consumers after this happens are going to be somewhat up in arms over what's been done to them. It's going to be the law of unintended consequences. Obviously, there were some areas of concern in what was going on in the property casualty business, and there were certain so-called reforms that could have improved the system, but instead they took out a kind of a meat cleaver, to kill a gnat. So
right. I think you're right, and I think initially it did have some of the intended consequences they expected it to have, and then these storms came along, and so now that has turned it all on its head.
It'll be very interesting to see, because a lot of people that just, they didn't take notice because they just didn't think it was ever going to apply to them. Right. Much like the changes in the law for medical malpractice. Well, there is no established group of people who are going to be medical malpractice victims in the future. Right. Nobody ever thinks it's going to apply to them. So when they come into our office after a loved one has lost their life, or, someone's had a serious act of malpractice committed on them that's left them with lifelong problems, they're really surprised when I kind of go through the history of what the law has been and how the law, unfortunately, actually protects negligent doctors more than the injured consumer. So,
absolutely. So speaking of, obviously, Helene and Milton, and Lori and I spoke a lot about this on our last show, and she did a great job kind of discussing that topic. But one thing we didn't talk about is the I think, a greater amount of rental cars that are probably on the Tampa Bay roadways right now, essentially by virtue of the fact that a lot of people's cars got flooded out. They no longer had vehicles, and then they had to get rental car vehicles. I saw someone lamenting about on social media about there's so many out of state license plates on the road and what's going on with the traffic lately, and everything's been bad. I think our traffic patterns, everything's kind of in an upheaval. I don't know if people have just been displaced and more cars are on the road. I really don't have an explanation for it, but I think the out of state tags that they're seeing are probably rental cars. And that brought up the thought in my mind is the fact that if people are in rental cars, they're not in the vehicles that they typically own or insured on their policies, and they unfortunately get in an accident and cause an accident, where does that leave someone when they get hit by a person who's driving a rental car?
Well, it leaves them hoping that the actual renter had very good coverage because, as you know, unfortunately, a number of years ago, there was a terrible law change here in the state of Florida, and then it went kind of national. It was they were advocating, rent-a-car companies actually right here in Florida were advocating that they shouldn't be responsible when someone causes an accident in their rental car that they rented the car to.
Right.
And so many, many years of existing Florida law was done away with when there was a thing they call the Graves Amendment. It was a federal law that said that, unfortunately, from now on, when a rent-a-car company leases a vehicle to someone and they cause serious bodily harm to you, you can only sue the driver.
Right.
Unless you have some direct act of negligence against the car company or the rent-a-car company, but it's very unusual.
Right.
It's effectively a rule that says we're gonna change the law. We know the law has been that if there is negligence on the part of the person who rents the car, we're going to allow a lawsuit not only against that person, but we're going to really want to encourage financial responsibility. So we're going to allow the owner of the company, the rent-a-car company, is jointly and severally liable.
Right.
And the thought behind that was, well, these are very, very big, wealthy entities, and they can insure for that, and they can spread the cost of that risk over many thousands of rentals.
Right.
And so that worked wonderfully for years and years and years. No problem. It's just the rent-a-car companies didn't want to have to pay if their renter killed somebody. Of
course.
So they managed to march into Congress and get that changed. And now you're on your own. Basically, when someone, that is renting a car, you better hope that they have coverage. And here in Florida, we're incredibly vulnerable to it because if you think about how many people come from all over the world to go to the Disney parks and then on to cruises and things like that. And these are people that when they're done, they get on the airplane and they fly back to Brazil or they fly back to Peru or they fly back to Russia. And, the chance of you being able to get justice if they leave you or a loved one, paralyzed or a loved one died, you are SOL, as they say, and I don't mean statute of limitations.
Not statute of limitations, right? Yeah. Yeah, and I want to ask you something, because typically the rental car is the replacement vehicle. It's covered under the person's personal auto insurance. But have you seen a situation where, let's say I'm insured by Progressive, I end up getting a rental car because my car is now flooded. Now Progressive says, well, that's not the car that was on your policy. This was not an insured vehicle.
I think we're going to see some of that now, but and I think the good news is a lot of policies say if you have a temporary substitute vehicle, your own personal insurance attaches to that new car.
Right.
And so that's a good thing, obviously.
Absolutely.
Because that could help you in that kind of a situation if it turned out, the only reason they're driving the rent-a-car is because theirs is flooded. And like you said, I've noticed the same thing you have. And because my own property flooded, I've been displaced down to downtown St. Pete. So I find myself driving from North Clearwater to St. Pete. And, back in the day, you used to see in magazines and books, I would see pictures of traffic jams, coming from places like LA and New York City. And now I can snap a photograph early in the morning when I'm trying to come up to Clearwater, or on the way home when you're trying to go south on 275, that would rival anything you see in LA. I mean, it's incredible. And right now, I have never seen so many restoration companies from out of state.
Oh, for sure.
Obviously, the brush removal type companies, these very big specialized, sometimes they're tandem movers.
Yeah.
And, just all kinds of, power companies, because for whatever reason, we haven't learned. And we just keep repeating history. They have these situations where they're allowing these power lines to go right through these huge oak trees, and they're cutting off like just a little below and a little above. And every time we have a storm, the same thing happens. These things are getting knocked over, and it's the same cycle over and over. And if you would think that they would just go ahead and say, you know what, we can't have any trees allowed in that easement.
Yeah,
we're not gonna trim it to try to make things look nice. We're going to trim it so that we don't lose power. But so far, we don't have the will to do that. They are hardening and putting some lines down. Other lines are putting up higher, than the actual, kind of greenery, so that the lines are actually above, the swaying branches.
Yeah.
But I've just been amazed as I've driven around and watched them actually still trying to partially cut. And when it's done, it looks like something that was performed by Walt Disney World. They cut these
the design.
beautiful little holes so that stuff can
go
get through.
through.
Yeah, it's interesting. But
And I don't even know that we're out of the woods, because as I drive home, I still see a lot of leaning, like the leaning trees that are like, those don't look all that safe. And I'm concerned that, there's still going to be some outages and things falling. I was just driving on, I think it was 38th Avenue North near 4th Street. There's a tree, I swear, I'm like, this tree is going to fall. you just drive right under it.
I've seen a bunch of them
hoping
also
that it's
area.
not going to happen. So
I've seen in Old Northeast, there's a property that has literally 3 palm trees at about 45 degrees. So I think the next time it rains and that ground softens again, thing, and it's coming down. It's not going to be sustainable at the rate that it's leaning.
Sure. Speaking of Old Northeast, this is totally off topic, but I just took that little scenic route. Was it Coffee Pot?
Yeah, Coffee Pot Bayou down there.
Sad. I was like, oh man, it's a lot of damage.
Yeah, beautiful homes.
Beautiful homes that were really, really damaged out there. But I'm sure it'll get back to the way it looked before. But that was a sobering drive.
Yeah, I actually had met someone that actually just closed on the house just before this, and it took incredible damage.
Oh man. Well, that is obviously off topic from what we were discussing, but I wanted to go back to it before we take a little bit of a commercial break. I want to talk about the rental car situation again, because you brought up a good point that I recently researched. So for anybody who's itching and thinking of ways that, well, how come the rental car company is not liable? What if they did this, or what if they did that? And the thing that I hear a lot, people, is the person that rented the car ended up having a suspended license or something like that. Is that enough liability to get around the Graves Amendment? And I said, oh, that's a good question. Let me research it. And I researched it recently. Unfortunately, it doesn't look like it is. Because, of course, if the person that is driving the rental car has very limited coverage, we're always going to try to look for ways to see if there's further liability in any way that we can find more coverage to, compensate our client for their injuries that they sustained. So I looked into that to see if there's ways around the Graves Amendment for the negligence of the actual rental car company. And unfortunately, I think from what my research has seemed to uncover is that just because a person does not have a valid license does not necessarily impute negligence. The reason being is if it's facially valid, and the driver's license is them, and it shows that it's not expired, that's essentially all they need to get.
I mean, it's tough. You really need to kind of look for active negligence on the part of the rental. And, by that, I mean, well, what happens if there's a recall, for example, of a defective, brake or defective wheel lugs, and the wheel falls off.
Right.
And, thereby causing injury. then you've got a situation where you're going to be able to reach the rent-a-car company. But,
Yeah.
The one-time thing that was called the dangerous instrumentality doctrine that still exists here in Florida for regular people.
Yeah.
If I borrow your car, of course, and you're going to be primarily liable if I cause an accident.
Right.
And after your policy is exhausted, then they're going to go after mine.
Yeah.
And so just regular folks here in Florida have that responsibility. But rent-a-cars don't. They've changed it just for rent-a-cars. So if you can figure that out, I'd really like to have that explanation. There's really no good explanation for it other than the insurance companies lobbied for it and they got it.
Yeah. And, I guess it was naive of me to think that you should at least be verifying that someone has a valid license before you hand them over a dangerous instrumentality. But apparently you don't have to, as long as it's not expired and appears to be a real driver's license. That's all they need.
Yeah. Even more ridiculous is they turned it into a federal law so that they could supersede anything to the contrary in any state.
Right.
And so, argued that had a lot to do with interstate commerce. It's just, but they got it done and it survived, all kinds of court challenges. So, people have no idea what's happened to them once again until, a loved one gets killed and they come in to meet with you and, find out, well, what recourse do we have? Well, sorry, the person that, rented the car had a $10,000 insurance policy.
Right.
So that's what,
that's what
effectively that's about what you're going to be limited to for a recovery.
Right. Well, I think that's a good stopping point before we jump into a couple other topics regarding, civil litigation and different things that we often talk to our own clients about that I think would be helpful for our listeners. But before we get into that, I think we should take a short commercial break. And before we go to the commercial, I want to just plug that we do have a community event tomorrow at our law firm. After all of this heavy conversation, we're still doing something quite fun for the kids and the family. So come out tomorrow at 5 for our trunk or treat event at our Clearwater office location, 1875 North Belcher Road. It starts at 5 o'clock. Hope to see you there. We'll take a quick commercial break and then we'll be back with Brian Caulfield and I.
This is the Tan Talk Radio Network.
After a car accident, there are many questions that you need answers to. Who pays for my car repairs? Who pays for the medical bills? What about my lost wages? And more. The personal injury law firm of Perenich, Caulfield, Avril Noyes has been answering these questions for their clients for nearly 70 years. Since 1955, they've been a voice of the injured in the legal system. As one of the longest established law firms in Tampa Bay, Perenich, Caulfield, Avril Noyes is here to answer your questions. Listen to their live call-in radio show on this channel every Tuesday evening from 5 to 6 p.m. or call them at 727-796-8282 or visit them at voiceoftheinjured.com. Offices Clearwater, non-attorney spokesperson.
This is the Tan Talk Radio Network.
And we are back. Thank you for holding on during that commercial break. Hopefully you're with us and you've been sharing this broadcast with friends and family. Let them know we're live on the air for the next half hour, giving you a chance to ask your legal questions live over the air. The lines are open, so feel free to give us a call. Get your questions in at 727-441-3000. Give us a call with your legal questions. As I mentioned before, my name is Jacqueline Bryan. I'm here with my partner, Brian Caulfield. We've been talking about some personal injury and different legal matters on the show. But of course, we'd love to hear from you. So feel free to give us a call or drop your comments in the chat on our Facebook live stream or our YouTube so that we can answer those live on the air for you. So before we went off for the break, we were talking about just some different topics. And I know that depositions are just a very important part of what we do in civil litigation in our cases. So Brian, did you have a question for me about depositions.
Yeah, I think a lot of people really don't understand what the deposition process is. And if you find yourself where you have not been able to resolve your insurance claim with the at-fault party and their insurance company steps in to defend them, and we file a lawsuit on your behalf, really probably the second big thing that you do in your lawsuit as an injured person is you give a deposition. And deposition is part of what's called discovery, where the other side's trying to discover facts about you, and they have different ways to do that. They have interrogatories, which are written questions you answer under oath. And then, you'll tell them, your medical history, doctors you've seen. They'll subpoena those records. And when they get those records, all of a sudden your lawyer's going to get a call, and they're going to say, we want the injured person to come and sit for a deposition. And so, Jacqueline, why don't you tell our viewers, first of all, what that means,
right?
And then kind of give some tips that, in your extensive history of practicing plaintiff's personal injury law representing only the injured person,
right?
Kind of give us some tips for giving a successful deposition that will help your case.
Right. And so, as you mentioned, my tips are certainly going to be tailored towards the plaintiff personal injury deposition because that's all I've ever done. And but don't mistake that to mean that these cannot happen in other kinds of cases. Certainly, depositions can occur in all kinds of civil litigation matters, and sometimes criminal as well. But with that being said, obviously, Brian, you can add to my list, but there's a few key things that I always make sure my clients understand. And one of them being is you should assume that the defense or the insurance company already knows the answer to every question they're about to ask you. And I think if you go into your deposition with that mindset, you'll do a lot better, because I think people tend to want to question why the question is being asked, and they want to defend themselves or what's the basis for that. Just assume that they already know the answer and answer the question as truthfully as you can, because the truth doesn't change. And so it's best to go into it with that mindset. You're not there to sell your case or defend the case. Let the lawyers do that part. You're just there to answer the questions and answer them truthfully. And the reason why I mention that is because, as Brian talked about, there's already have been some form of written discovery that's already occurred. The interrogatories and the non-party production, they've sent out subpoenas to your doctors and various places, even your employers sometimes. And so they have a good deal of information about you already. And they've also done other things like scroll through your social media accounts. And they've, probably sent their investigators out to watch you and to try to get a sense of your daily habits and your routines and things like that. So those are all possibilities. And so when you're going into your deposition, it's best to be as candid and honest about your prior history, your other cases, your other claims, any other injuries you've had. But of course, of informing your attorney about those things as well, so that your attorney can properly prepare you for that. Keeping your answers concise is always something that I like to recommend. Typically, the more you say, the more you tend to open the door to saying something that could unfortunately harm your case. I remember when I was a law clerk on the other side, I worked for an insurance defense firm. And the defense lawyer at that firm would often say, I let the plaintiff talk, because the more rope you give them, they'll eventually hang themselves. And I think that's true, unfortunately. I think people, they get nervous and they have a tendency to talk. And unfortunately, the more they talk, the more they start to put their foot in their mouths. And so I think the best response should be limited to yes or no whenever you can. Keep it short and sweet. I think that's probably some of the best advice I can give. And of course, listen to your attorney. Your attorney is going to spend quite a bit of time preparing you for that deposition. And the worst thing you can do is forget what your attorney, advised you. And I think that meeting is for a reason, because they know what the deposition is going to be like. They know what kinds of questions are going to be asked. They know what kinds of things can be said that can hurt your case or help your case. So listen to your lawyer. That's probably some of my key advice on that. I don't know if there's anything you want to add before I get into another question that I had about depositions.
Yeah, there's a number of things when I talk to clients about this, because one of the first things they're trying to do is to build contradiction.
Mm-hmm.
They want to basically show a jury that you are not a credible person. And so there's some tried and true methods to doing that. The first thing is they're going to ask you a bunch of specific questions as it relates to your physical capabilities.
Right.
They're going to ask you things like, what's your hobby? Golf. Have you been golfing since the time of this accident?
Right.
No. Well, what just happened there?
Mm-hmm.
What happened there was someone just denied that they'd ever played golf since the time of the accident. Well, you should be reasonably, sure that before they're asking these types of questions, there's a reason for asking it,
Mm-hmm.
because they might already have surveillance video of you golfing. And then when you try to say later on, oh, well, that was just one time I went,
Mm-hmm.
and, I quit after the, eighth hole because I was in such pain. Well, then the answer to the question would have been, well, I have tried to play one time, and unfortunately it really bothered me,
Mm-hmm.
and I quit after the eighth hole.
Right.
And you don't damage your case. So I tell people, number one, listen to the question, to the entire question, because the words at the end of the question can change the entire answer.
Right.
Number two, answer the question and only the question. And then sit patiently and wait for the next question. Do not anticipate, do not volunteer as to where you think the person's going to be going.
Mm-hmm.
Always remember that the person questioning you, no matter how much they smile at you, they are your adversary.
Right.
And they're trying to have you let your guard down. And you said something interesting that I want to expand upon and I want to reinforce. Listen to your attorney. Your attorney's there to try to help you. And if you're going to sit there and you're not going to listen to what I have to tell you because your Uncle Louie said, here's the way that you should respond, and this will get you maximum amount of money, because this is what happened to me in New York, that's advice you shouldn't be following.
Right.
Or you should have hired them to handle your case. And that's really important, because I've had that kind of conversation where whenever I get clients that are nervous, they feel like they have an obligation to please the questioner. And so they feel like sometimes when they're asked a question that they don't know the answer to, they just go ahead and make something up that sounds good because they figure, well, I was asked a question, I guess I'm supposed to know the answer.
Right.
And if I don't respond, maybe I hurt my case. And so you can't put a filter where the question is asked of you and you try to say, I wonder what the best answer for my case would be, and that's what I'm going to give. I tell my clients, tell the truth.
Right.
You're not the smartest person in the room. You're not going to outsmart this defense lawyer.
Right.
And the reason, as you said, they're asking the question is because many times they already have the answer and they're looking for you to contradict yourself.
Yep.
As to proof that they already have.
Yeah, Ed, what's up?
Can I quote Judge Judy?
Sure. Go ahead.
If you tell the truth, you don't have to have a good memory.
That's absolutely right.
The
truth doesn't change.
Yeah, no, that is true. I mean, and look, when you have a personal injury case, you have a lot of people that are very negative towards personal injury cases. Let's face it. Unfortunately, there have been instances where a few bad apples spoil it for everybody. Someone who's not being truthful about their claim gets discovered. And a lot of times you have jurors thinking that these kinds of cases are in general suspect.
Mm-hmm.
And so, that becomes, you don't want to confirm in a jury's mind that your case is one of those where you're trying to get something that you're really not entitled to.
Right.
And so credibility is key. It can wreck your case. And, if the answer is, I've golfed once, or I still golf, but I just can't do it as well or as much, that needs to be the answer.
Exactly.
Because otherwise, as you know, you can damage your case so severely that you lose the entire case, even though it was a serious accident.
Right. And you made a great point about credibility and, the way that you're going to present. So that's another thing that I remember doing as a law clerk. I'd have to summarize the plaintiff's depots often. So I'm just there to listen. I would sit in on the depot while the defense lawyer would depose the plaintiff. And my job was really to kind of assess the plaintiff and determine if this person, would present well in front of a jury. And I tell people, whether you realize it or not, the way you come across in your depo could impact how the defense attorney writes up their report to the adjuster to determine, is this case going to settle, or are we going to push this case towards trial? And so a lot of times people will go, this depo is going 3 hours. I'm agitated now and I've got a bad attitude. And now my answers are short and I'm getting snarky with the lawyer. And as you start to deteriorate, I think that's something to remember, that try to keep yourself composed. I know it's not fun. No one wants to be in an hour, 2 hour, 3 hour long deposition. But at the end of the day, they are evaluating you.
Yeah. I like to tell clients that, I've now been doing this for 35 years. I've had a lot of jury trial experience. And one of the things that I kind of tell clients that it really gets down to, does a jury think that you are worthy of compensation?
Exactly.
And that's an interesting way to put it, because it's always supposed to be, well, is this true? Is this false? And it's black and white. But, a lot of times it's whether the jury, feels for you, whether they believe you're worthy of compensation.
They sympathize, right?
Yeah. And so, that's why it's so important to really look at all aspects of the plaintiff's appearance, of, the way they're conducting themselves, the way they're dressing, and of course, I'm always telling my clients when you do have the jury trial, hey, just assume that the person you end up with, an argument over a parking spot could be your juror.
Right.
So you got to be very careful when you're at the courthouse. You don't bring friends. It's not fun time where jurors see you out in the hallway during a break laughing and carrying on with some family member, because that looks inconsistent to them with, wait a minute here, this person has such a serious injury. How come they look normal?
Yeah.
And so you have to be so very careful that things don't get misconstrued.
Yeah, but you also don't slap on the neck collar as soon as you get out of the car and pull off the walker and that sort of thing.
I actually had a case where that occurred. And it was,
it's like made for TV.
Look, it was very interesting because they set the lady's deposition and it was in Sarasota. And I'll vividly remember this for the rest of my career because this was actually her updated deposition. She'd already given her first deposition, and this was as we were headed towards a trial. And what was interesting is when they set the depo, they knew where she had to come to, a parking lot, and they had surveillance video there.
Yeah.
And the surveillance video shows her pulling up into the parking lot, and she's on her phone. And she's not on her phone in a sense where she's hands-free. She literally has the phone, being balanced on her, shoulder. And she comes whipping into the parking lot because she's a little bit late. And interestingly enough, she gathers a very large purse and throws it over one shoulder, and the other shoulder, she's still trying to conduct a conversation. And she swings the door open and kind of jumps out of the door and walks literally 50 yards towards the front door of the deposition until she realizes something. She forgot her cane. And so she went back to get the cane and came up and came into the deposition walking. And honestly, when that was shown to me, that was the end. I said, I'm not going to represent you, and
that's horrible.
It was, but I'll never forget it. So, I'm all for, people that are not honest being discovered. That's what the system
should be doing. Right. Absolutely. Absolutely. But like you said, if it's a situation where, look, I tried it, and when I got home, my back was in pain. I was laying in bed for 4 hours after that. I had to take pain medicine. Their surveillance camera isn't going to show all that.
Yeah, and I like to tell clients, I play offense. I don't play defense.
Yeah.
All the time that I spend playing defense on a case is lowering the value of your case.
Yep.
And frankly, there just comes a time when if I have to play too much defense, I don't want the case. And I'll tell clients, I think you better take this offer because I think you're at too much risk of getting less than that.
Absolutely. I want to get your take on something because I don't know if you're a TikToker, if you have a TikTok account.
I think I'm one of the many millions that, you're laying awake at night, or sometimes I'll wake up at 4 in the morning.
Yeah.
And I don't know why, but I'll just decide I have to kind of make a little journey into the world of social media.
Yeah. I mean, TikTok can definitely consume you. There's a lot of funny, interesting, informative, all kinds of things on there. But that being said, I came across a gentleman who was kind of like documenting his personal injury lawsuit on TikTok. And he'd actually sustained a very, very severe injury, amputation to his leg. And I'm not entirely clear who he's suing, but it seems like maybe he's, long story short, I think he got out of the side of the road to like fix his car, maybe fix a flat. And the way the construction cones were set up was in a poor way. And so they're going after the construction company because the car came by, hit him, took off his leg.
Okay.
Right. So he's chronologic, whatever the word is, he's documenting, blogging.
Sure.
His journey. And he's quite detailed because he takes the vlog into his doctor's appointments. He takes the vlog to, therapy. And when the therapists come to his home to work with him, he's vlogging all of this. And he's quite a funny guy. He's makes light of it. He's got a great disposition for someone who's lost a limb, But I'm thinking about all this and I'm like, eesh, I don't think you should be doing this with your injury case. And he's also makes comments about, jokingly how after all this is over, I'm going to be rich. And, this but don't feel sorry for me. I'll get paid kind of thing. And I'm like, I almost want to be like, does your lawyer know that you're that you're doing this? Make sure you talk to your lawyer about this vlog. But I'm like, I don't want to be the Debbie Downer in the comment section, but it's like
exhibit number 1 will be statements like that because let me tell you, it gets back to what I talked about.
Yeah.
Are you worthy of compensation? If you can bet those particular select videos will be pulled out of the many hundreds that you've done,
right?
And they will try to turn this case all about into all this person really wants is money. They're not, they're actually happy, and they're just, saying they've been so damaged. Frankly, they can do just about everything they could do before.
Right.
If it's a leg amputation, the person wasn't a track runner and this, that. They'll turn it into a case where, unfortunately, your guy's going to now be playing defense. Why is it that you said that you're going to get paid, you're going to get rich? Because that's the kind of thing that can sink your ship. And so with respect to doing the vlog itself could be very informational.
Depending on how it's done, yeah.
And, as long as you're truthful, you're fine. But when you start venturing off to statements regarding motivation as to why you're bringing the case, you are treading on extremely dangerous ground because, like I said, the defense lawyer's job is to make the make the jury feel that you're not worthy of compensation, that you're not credible, that you're trying to get something for nothing, so to speak,
right?
Or you're overblown in your description of what this has done. And the last thing you need to do is create Exhibit A for them.
You've just handed it to them on a platter.
They'll live to regret those posts because you can bet part of, you have a limited period of time in front of the jury to explain and show what's happened to your life as a result of the traumatic injury you've suffered.
Yeah.
If part of that time is spent on defense, that's bad.
Yeah.
And so you're just building multiple opportunities for that. So not a good idea. I wouldn't recommend it.
Right. And like you said, unless it's done in an honest way, and then I think it should be monitored by your attorney if you're going to do it. But because I think there's so much room for error and so much room for what you're posting to be misconstrued, and it can be edited in the sound bites and so forth. My rule of thumb is just don't do it. Don't vlog.
Excellent
don't
rule
post,
of thumb.
Don't just stay off of social media. That's one of the questions, going back to your deposition, that they're going to ask. Do you have a social media account? And a lot of times they'll ask, have you posted about this accident or your injuries or your treatment on social media? And if you say yes, You've just opened the door for them to start digging and asking the
Absolutely.
court for them to be able to get all of
The
your.
next question they ask, and like I said, I've been doing this for 35 years, long before social media was out there. One of the favorite questions was, have you been on vacation
Oh, yeah.
since the
They
time of
love
this
that
accident?
question. Yeah.
And then, they're hoping that they can find pictures of you ziplining in Costa Rica,
Sure.
or, pictures of you riding a horse,
Yep.
or pictures of you on a deep sea fishing trip where, the rod is bent over and you're catching a big black drum,
Right.
or some huge, grouper or something like that. Because
Right.
I've had that kind of situation take place before. So, yeah, I mean, you have to obviously be diligent. You have to always
important.
expect that, the truth of the matter is you're under the microscope. It's really not the defendant's conduct in most of the cases we have. It's pretty straightforward, rear end collision. There's really nothing to see here. The person was negligent.
Right.
And so really, in my experience, the way most of the cases I handle are defended is the bigger focus by the defense is on causation and damages. And that basically twofold. Number one, your damages are not as severe as you say. And number two, even if things are as you say, those problems were not caused by this accident. It was a prior accident. It was a subsequent accident. It was a degenerative process. Anything but their accident.
Mm-hmm.
And so that's why they're asking for all of your history of accidents.
Exactly.
So that's very important.
And it's best that you always share that with your attorney. We did get a comment on Facebook just saying this is great information. Never thought about all of this. And it's true. A lot of people don't think about it. They just think I was in an accident, I was hurt, and I should be, made whole. But they don't realize that your prior history and causation and all these different factors are going to all converge together to determine the outcome of your case. And so that's why it's very, very important that you are candid with your attorney about all of these things, because they're looking at your social media, they're surveilling you, they're sending the subpoenas, and they're going to have all the priors. And sometimes they have more information than your attorney does. So if you're not sharing it with your attorney, as Brian said, now we're on the defense, and that's not where you want to be. So as we're winding down, we still have the lines open. If you have a question or comment, you'd like to join in the conversation. Again, that number is 727-441-3000. Again, that's 727-441-3000. And I did want to talk about this topic. I think that's probably the last one that we'll have time. But I think I find myself often explaining this topic to clients because it's an effective tool, and I think on both sides of defense, for plaintiff and defense, to use in ways to either get the case resolved or put the case in a better posture or position at the time that it goes to trial. And that's proposals for settlement, which before my time, I guess they used to be called offers of judgment. So I hear people use them interchangeably, but I've only known them as proposals for settlement. But that's something that I think clients have questions about. They're not really sure what they are. Sometimes they get filed on us. Sometimes we decide to file one on the other side. Could you explain what a proposal for settlement is and how it's used in the personal injury litigation setting?
Sure. In this day and age, when you're in a lawsuit and the other side really is the insurance company, that is paying for the defense of, say, the offending driver in your case, they will make you a formal offer. And basically, there's a certain way they go about doing it, and it's called a proposal for settlement. So, for example, if they offer you $10,000 and you say, I'm not interested in taking that, if they do this special offer and they put it in the correct form, then you have 30 days to think about whether you're going to accept their offer. If you do not take it, and you don't have to call them up and say, I'm not taking your $10,000 offer. If 30 days goes by after they file it with the court and you haven't filed a written acceptance, it's deemed rejected. And it'll just sit there in the court file to wait until the end of your case. So if you have a jury trial and you get 25% less than what they offered you, then you are going to get punished by the court for not taking that $10,000 offer, because now the jury has given you 25% less than that, showing that that was a reasonable offer, and the court will punish you. So if the jury gives you $7,000 and you think, oh, well, boy, I'm really upset, but I guess at least I get $7,000. No, you don't.
Not
you
quite.
get tapped on the shoulder and you get told, well, we're going to have a hearing to see how much in attorney's fees and costs was spent by the defense after they made this offer to you. And you have to reimburse them out of that. And chances are that will cause your $7,000 win to turn into a $50,000 loss, where you'll actually have a judgment entered against you because you have to pay the other side's attorney's fees and costs.
Right.
So it is an extremely significant development. One piece of good news, you can do the same to the enemy.
Goes both ways.
You can send a proposal for settlement to them and say, I'll accept $100,000. And if you go to trial and get 25% better than that, then what will happen is they will be punished for not paying what you asked for to settle the case. So if the jury comes back 25% greater than the 100 that you offer to settle for, then they're going to get punished. They're going to have to pay attorney's fees and costs incurred after the date that you made the offer. And that can be very significant. And so whereas the contingency fee contract said you have to pay 40% of your recovery, you get help paying that 40% of the recovery, because the judge will hold a separate hearing for attorney's fees and costs and make an award to you of that is in addition to what the jury gave. So, they're very, very important things to consider.
Absolutely.
They're almost always filed against our clients,
right?
Because it really scares the heck out of people, because they can end up owing.
They try to send a message by
big money
filing those, and I've seen a lot of times, especially in premises cases, where they will file one that's ridiculously low and just almost insulting, to kind of send that message, like, look, we're throwing this out there to let you know that this is how we view your case, kind of thing. And it scares, plaintiffs. But to that end, is there any real impact short of trial? If the case does not go to trial, let's say it's headed towards mediation, should our client really be considering the impact even before the trial is actually here?
Well, as you point out, it really only activates if there's ultimately a jury trial. Otherwise, the case gets settled. But, sometimes you can actually really help yourself if early in the litigation, let's say you don't have a very big policy and you have a very serious injury case, and they don't offer the $50,000 policy, even after you said that you would take it. And they come back right before at the courthouse steps saying, oh, we changed our mind. You proved to us that we really should give you the 50. You say, no, I'm not taking that 50 anymore. I gave you that opportunity a year ago. You put us through this. So now we're going to go to trial. We're going to get 25% more. And your client's going to be responsible for attorney's fees in addition to the jury's verdict. So, there's all kinds of strategies that deal with that.
It can be an effective tool.
Yeah, it can be an effective tool.
Yeah.
Typically, it's not used, though, until after mediation is what I found.
Right. Exactly right. And what I've seen here recently, because of the influx of lawsuits as we close out, is that it can also be a good tool when you just have an adjuster who's fallen asleep at the wheel. They stop responding to your demands and negotiations, and so you slap them with a lawsuit. The 91st day, you file a proposal for settlement. Oh, now they're
That'll
awake.
Wake them up.
Now they're awake, and miraculously somehow the case resolves. So, but hopefully this has been an informative show all about personal injury laws. We are the personal injury lawyers at Perenich, Caulfield, Avril Noyes, Tampa Bay's oldest injury law firm. We are here every Tuesday at 5. Would you like to say goodbye, Brian?
Well, thank you very much for having me, Jacqueline. Always a pleasure to be on, and always a pleasure to be educating the public. The law office is now closed.
All right. See you next week.
WTAN, Clearwater,
FM 106.1,
WDCF, Dade City,
FM 102.3.
Listen.
That's have some high-profile appearances. Donald Trump at a roundtable in Pennsylvania was asked about the controversy over remarks made at his Madison Square Garden rally, a comedian calling Puerto Rico an island of garbage.
No president's done more for Puerto Rico than I have, so thank you. That's really nice of you to say. Appreciate it. Thank you, Mayor.
Earlier, he spoke to supporters at Mar-a-Lago. Reporter Libby Cathy has that.
Towards the end of his 54-minute remarks, we heard what we think the purpose of having this press availability was to serve as a pre-rebuttal to Vice President Kamala Harris's speech at the Ellipse tonight. He said that Harris is unfit for the presidency. His quote, he said that